seeking jointer or seeking to be joined as an interested party in this matter, and because of his vast experience in financial and economic matters, my Lord will not be opposing. Is actually coming to cross-pollinate this particular petition. My Lord, as my learned senior counsel, Honorable Kalonzs has said, Safaricom Limited Company is in Iran Republic. So therefore, what they are saying, my Lord, my ladies, is that they do not want to cede the control of this particular strategic national asset to foreigners, where the headquarters of this particular company are in Nairobi. The Lord, before even I proceed further, there are other petitioners, because this is the lead petition, and I've not even heard. I don't think you took the quorum of them. Because this our petition, E51 is the lead petition, but I think there are two more petitions.
I don't Kalonzs will produce all the advocates for petitioners.
Yeah.
Those petitioners are appearing in persons.
They are appearing in person.
Yes.
Yeah, we'll come back to that.
Yes.
You are going to question.
Yes.
But it will be profitable if you give us information in addition
Yes.
to what has been submitted by senior.
Yes.
Rather than repeating.
Yes, my Lord. So therefore, my Lord, we are saying that as early as I think the 13th day of this month,
Yes.
the Attorney General also filed another affidavit actually saying that he got approval from Parliament, which actually consolidate our fears in the petition that Parliament is being coerced by the Attorney General, by the Ministry of Finance, or by the Treasury, to cede its Article 95 and 94 responsibility of oversight. It's a clear indication. My Lord, every party, including Ajawara, who actually says that they should be struck out from this particular petition, will be highlighting their own application, which we have opposed, and we have written submissions to that effect, but we await directions from this court. You know, with, on top of what my learned senior counsel, Honorable Kalonzs has said, we'll also be seeking directions whether the law firm of Andrew Mukite Musangi can represent Safaricom, Safaricom being regulated by the regulator, because Mr. Musangi, as we do know, is the chairman of the board of directors of Central Bank Kenya, which is a regulator to Safaricom. My Lord, we'll also be seeking direction as to whether the law firm of OK,
You said this, Mr. Musangi is the chairman
of Central Bank Board of Directors, and therefore there is a clear conflict of interest on Mr. Musangi's side, because he's a public officer, having been appointed by President Ruto in 2023. I don't remember the exact date, but he is the chairman of the Board of Directors Central Bank. Unless he sits that position here, for him to continue, we'll be very happy for the President to appoint another chairman of the Central Bank Board of Directors, for him to continue dealing with this matter. Your Honor, we'll also, my lords, my lady, we'll also be seeking directions as to whether OK can represent the Attorney General, going by the recent pronouncement by Justice Mohochi Nakuru, that the Attorney General cannot be heard to say that the able state councils they have in the Office of the Attorney General can go ahead and procure private law advocates to represent him, and more so in a public interest litigation. because this is a pure public interest litigation. My learned colleague has said that it joins the most marginalized communities in the digital economy. Every village, including my own village, Nairigi Akari, and even Saikuru, where my there are so many M-Pesa shops there, meaning that the people there, Mamambogas, as we call them, I try as much as possible to avoid that terminology, is connected to digital economy via Safaricom. And therefore, my learned colleague very eloquently said that we do not, or the petitioners do not want to cede. They do not cede any more shares to foreigners. In those few words, my lords, my ladies, I invite my learned colleague, Mr. Jiro, very briefly.
My lord, I want to associate myself with the submissions made by my learned senior counsel and my learned friend, Mr. Lempa. And just to begin by commenting your lordship, that the reason why we are seeking clarification of the participation of the farms is on the basis that Justice Mohoshi gave a rider that unless there is a formal approval by the Attorney General, this morning your lordship has gone on record that we have a counsel originating from the office of the Attorney General representing that party. To the best of my knowledge, your lordships, that approval has not been shared to the parties and or brought before this court. Nor did the council have the obligation of disclosing to the court of the existence of that particular approval. Those are orders of your brother are still in force, your lordship, my lady, and they cannot be wished away. Number two, your lordship, is a question that was raised of the sovereignty. Safaricom sale must be viewed in the context of the sovereignty of the people and the question of territorial integrity. Why do I say so, your lordship? It's because if you go to section 44 of the Election Act, the Election Act has provided a provision for integration of system. The IEBC system, they call it electoral integration system, with Safaricom being the primary data host and being the primary conveyor belt of the data emanating from IBC to Safaricom.
Lordship, if I may, with your permission. Yes. Apologies for cutting my colleague short. Lordship, there is a court of appeal authority that says that parties are bound by agreements. There is no mention of election-related issue in all the three petitions. If they so wish to include what they are submitting on, they have an application for amendment of the petition, which has been made ordered. So that your lordship, we also must get an opportunity to respond to those issues relating to election. That is their issues. They must restrict themselves to what they file and what is before this court, so that all of us can respond. So those are issues of elections, are issues of evidence from the bar. There is no affidavit that has been filed on the record and related to what they are submitting on. That's fine, Your Lordship, but it is not in our fact. That's fine, Your Lordship, but it is not in the issue. I stand guided.
My Lord, I think where counsel is straying from the documents is to now say they have to use Safaricom. The law says you will use an integrated electronic data system, period. It does not say you will use Safaricom. So stick to the law.
Stop at what
and
the
don't,
law says.
Yes,
I will stop at that.
the law.
Yeah.
You need to draw the line.
In fact, I've ordered a comment about section 44.
I will stop at that.
Stop at that.
The court will do the
Yes.
inference.
Continue.
So, your lordship, and having, of course, made the justification for the application of leave to amend the petition, Your Lordship, I want to go to the next limb on why the orders of justice, your brother Justice Mugambi, ought to be extended.
In addition to what senior counsel submitted.
Yes, Your Lordship.
Is not repeated.
In addition to that, Your Lordship,
Yes.
the question of public interest in this particular proceedings is of paramount importance. That this is not a dispute between a buyer and a seller. It's not a dispute. It's not a per se commercial dispute that is before you. It's a dispute that goes to the root of the sovereignty of the data contained by the or held by Safaricom, the security of that data, and the importance of knowing how that data shall be regulated and by who shall be the custodian of that particular data. As indicated, Your Lordship, the 30 million or over 30 million subscribers to Safaricom are before you this morning. And they are before you this morning pursuant to 40 million, I'm corrected, by pursuant to Article 22 as read together with the Article 258 of the Constitution. So the persons before Your Lordship is not Tony Gachagua. It's all of us who subscribe to Safaricom. That alone, as read together with the Supreme Court decision in the case of Peter Katirao Munya, the question of public interest demands that the court does extend the orders as granted. Additionally to that, Your Lordship, the case of Dimar Florian versus Director of Migration, which is petition number E074 of 2022, justifies the extension of these orders. And in this case, the court was looking at the question of public interest again.
What inconvenience, what prejudice will the members of the public suffer if the sale of Safaricom is to be okayed, if the orders are to be lifted? I'm sure the respondents will argue that the sale of Safaricom is going to generate public resource which might be plowed back to the public. But there are competing interests here. That I, Ndegwa, am a subscriber of Safaricom as a private subscriber representing 40 million of others, versus the interest the government is indicating that they want to raise resources, they want to raise finances. These competing interests, Your Lordship, must be balanced in favor of the parties who stand to suffer more, who are the subscribers. Why so, Your Lordship, as I pen off? It's because this is not the only means which the government can deploy to generate resources. While I endeavor the subscriber of Safaricom is the only platform that I can participate in the data technology and the digital economy. That is the only platform. That competing interest, Your Lordship, the balance tilts in favor of the persons that Tony Gachagua represents this morning. As a question of the amendments to include the 8th respondents as proposed, Your Lordship, again, there is no inconvenience that will be suffered or prejudice if Vodafone Kenya is made a party to these proceedings. In matter of fact, Your Lordship, under Mutunga rules, as indicated and quoted correctly by a senior counsel, is that the inclusion of the respondents will have the effect of completing the pleadings, in the sense that, Your Lordship, that Vodafone is proposed to be the ultimate beneficiary of the sale, while knowing that they are currently shareholders of the existing Safaricom. At the fullness of time, the question of the insider trading will be before Your Lordship, and whether it can arise at the fullness of time, as and when the amendments is granted. I rest my case.
So those petitioners who are in person, before we come to you, Walker, before we come to the response. Petitioners who are in person,
Your Honor, I'm ready.
are you a petitioner?
Yes, right of Honor. Petition number 2.
You are a petitioner?
Number 2.
In which case?
This case.
Are you represented? You know, we don't want duplication. When you are able representation,
Your Honor, you not have the mention by representing. I talk about representing somebody else.
Yes.
You not have the mention my name in the case.
It's actually citation. Simple citation.
oh, in the citations? Yeah, we will add you there. That's okay, thank you. All right?
Yeah, so
Mr.
I will represent myself, Your Honor.
Oh, you are in person?
Yes.
Oh, you are not a legal counsel?
No, I'm not, but I represent myself. I'm capable.
Oh, you are people?
No,
Yes.
that's not that is not the question. The question is whether when he presented the petition,
Yes.
he was represented. And he is represented and he
Yeah,
still
this
is.
petition was filed through legal counsel. That does not mean that we cannot allow you to speak.
Yes,
But
that's,
with regard to this matter, right? With regard to this matter, unless there is something very new which has not been stated, we will not allow you to speak for that. Okay?
yes, but I have
If there
something
is
new.
something which you think should be added.
Yes, Your Honor, I have something very
Or
new.
you can talk to one of the councils to raise it in reply. There is another time of reply. They will reply what you say here. So that opportunity is there. And you converse with them.
Your Honor, I have something to say which is new.
Which is new.
Yes.
Well, what is it before I even record it?
Remember, Your Honor, this petition is not just about Safaricom sale,
Yes.
but it's also connected to the proposed infrastructure bill, infrastructure fund.
Fine.
Yes. And given by the facts that have been stated in this matter, it is very clear that whatever they are trying to raise by selling Safaricom
Yes.
to collect to put infrastructure fund is so much a drop in the ocean that it cannot help the situation, because a government that has 13 trillion debt cannot sell something for around 200 billion to sort out that debt hole, because the argument was that the government is so indebted, so you are selling Safaricom to put the funds into infrastructure fund, and I know that the debt is so deep.
I'm sorry, my lord, but we have to rise again.
Yes.
This is a really misconceived proposition.
Let me direct it. That's why you see, I say that I'm not the record.
I will wait for the direction.
Now what we do, I'm getting your argument, but it is an extension of what Gachagua was talking about. And in reply, when that time comes, and you whisper to them, the country is just next to you. And then when we come back, Gachagua will tell us the way to proceed, so that you don't get confused.
You are ready.
Just take your seat. Continue talking, yeah?
I continue talking.
No.
My lord, the matter is sorted. The matter is sorted. The petitioners are Tony Gachagua and my friend Ogola. It's as simple as that. So whatever we have said, we represented. But as we amend the petition as well, given the opportunity, we'll also take into account what is talking.
Yeah, what he's talking about. That will be done. So during your time of reply,
We amend, we are
we had discussed. I was telling you continue talking with the Edward Giro, right?
Yes, Lordship.
Yeah, it
I'm well
as
guided.
long as you don't- All right, thank you. There's any other petitioner? Any other petitioner? All right, let me come to you, Ohanda. I know you also organized in Canada. There will be no repetition.
Yes, my Lord, we will try not to repeat the points that we want to make. We will also try not to be sensational. We will try not to engage in rhetoric. My Lord, let me start by saying that with respect to the applications for joinder, those will be opposed, and they can join the queue of applications.
So you oppose?
We will be opposing any applications for joinder.
What are your reasons?
They do not meet the strictures set out by the Supreme Court itself with respect to the question of the joinder, interested parties, and what they add to the contest before the court. When the applications are served, my Lord, and we have the opportunity to respond, as we must be given.
You are not being served? Anderson said we are served everybody. Anderson said we are served everybody.
Yes, when they're served, we will respond. It is part of the directions that my Lord will give.
Yeah, well, I'm asking you to give them the reason why you think we should allow them.
And I say, my Lord, I stated that the Supreme Court has given us the parameters which relate to the question of joinder of interested parties
Yes.
and what they add to the substratum of the contestation before the court. It is a respectful view which we will put forward more fully in our responses, that the applications for joinder do not meet those strictures. And my Lord, it must be borne in mind that we are not now arguing the applications for joinder. We are merely expressing the fact that we will be opposing them. My Lord, the next point I wish to address is the questions regarding representation. Once again, when and if formal applications are brought, we will